All right, let's talk. I've just gone through the full transcript from the court case in South Africa about Edgar Lungu's burial. And honestly, what I found was surprising. There's a lot being said online, but when you actually look at what happened in that courtroom, it becomes clear that something didn't go well for Lungu's legal team. Now, I'm not here to sensationalize anything. I'm going to break it down properly, in plain terms, so that everyone can understand what happened and why it matters. You'll see where the arguments were strong and where things started to fall apart. And yes, I'll also go through the actual clip or audio extract so you can hear it for yourself. If you want content that explains these things clearly and honestly, go ahead and like this video so it reaches more people. And if this is your first time here, consider subscribing. Let's get into it. So let's start from the top. This wasn't just a case about burial. It was about power, about identity, about who controls the legacy of a former head of state. The legal question was simple. Should Edgar Lungu be buried in South Africa, where he passed away? Or should his body be returned to Zambia for a state funeral? But when the court started, it quickly became clear that the arguments weren't going to stay simple for long. Lungu's lawyer, representing the widow, came in swinging. He argued that the former president's body should remain in South Africa out of respect for dignity, culture, and the pain of the widow. He cited the South African Constitution, Section 10, Section 15, Sections 30 and 31, talking about personal dignity, religious freedom, and cultural practices. But here's where things started to unravel. And this is where I want you to pay close attention. One of the first major blows came when Lungu's lawyer stood up and said, "We cannot say where he wants to be buried. My lord, I cannot make that submission." Right there, that line opened a huge gap in their case. Because in South African law, and in most common law systems, the starting point is the deceased's wishes. If Lungu's lawyer is saying he doesn't know what the man wanted and cannot make that submission, that creates uncertainty. The other side, representing the Zambian state and Attorney General, jumped on that gap instantly. Calmly, they pointed the court to paragraph 7.6 of the founding affidavit, the one Lungu's family themselves submitted. In it, the family acknowledged that the late president didn't want Zambia's current president to play any role in his funeral. So what does that tell us? That his wishes were known. The claim that there were no clear instructions? False. And it came from the family's own documents. That's what we call a courtroom ambush, using your opponent's affidavit to expose their denial. The judge picked up on that immediately. Then came round two. Lungu's lawyer said there was no agreement between the family and the Zambian state. No arrangement. No common understanding. But again, boom. The Zambian side pointed straight to paragraph 9.5 of the supplementary affidavit. In it, the seventh respondent, Mr. Zulu, clearly outlined a compromise agreement between the parties. That agreement included specific terms about how the body would be repatriated and what conditions would apply. So how do you explain denying an agreement when your own team signed off on it in writing? Court. Pants down in open court. From where I was sitting, you could literally see the body language shift. The judge's head tilted. The opposing lawyer didn't raise his voice. He just kept calmly pointing to the paperwork. That's how you know the facts are doing the talking. Now let's talk about one of the most debated terms, the word preside. Lungu's lawyer made it sound like Zambia's president would dominate the funeral, that Hichilema would lead the ceremony, control the day, and disrespect Lungu's legacy. He said the Zambian state wanted to force this through, against the widow's will. But then came the clarification. And honestly, it was a turning point in the whole argument. The Zambian side made it clear that Hichilema would not lead the funeral. He would attend. He would be present during military honours, and he would receive foreign dignitaries, as any head of state normally does. The actual funeral service. That would be led by a bishop, not the president. This is protocol, not politics. But Lungu's side had turned it into a power struggle. And here's where it got embarrassing. Earlier in the process, the same lawyers who now objected to Hichilema's presence had actually agreed to those limited terms. It was in the paperwork. So again, they were now rejecting something they previously accepted. In court, that's called inconsistency. In real terms, it's like saying, yes, that's fine on Tuesdays and shouting absolutely not on Wednesday. And expecting the judge to ignore that. That wasn't just a contradiction. It made the lawyer look like he was moving the goalposts. But it didn't stop there. Another critical moment came when Lungu's team said they were blindsided, that they were only informed of Zambia's decision not to repatriate the body on the 18th of June, and so they had no time. But then the judge asked a simple question. Why did you only file your urgent application on the 25th, the actual day of the funeral? No answer. That's 7 days. In urgent court matters, time is everything. If you wait too long, the court sees it as poor planning, not real urgency. So instead of looking like victims, Lungu's team started looking disorganized. And that hurt them badly. Then came what I'd call the quiet knockout. Lungu's lawyer argued that since they had already spent money on funeral plans, venue, arrangements, logistics, they should not be left with the cost if the court blocked the burial. But again, the Zambian lawyer kept it calm. He told the court, if you plan a funeral before resolving the legal issues, that's on you, not the applicant. You can't make decisions based on assumptions and then expect compensation when the law doesn't go your way. At that point, even the judge admitted that this was a novel request, meaning there's not even solid case law to back it up. Lungu's lawyer was left floating. No clear ruling, no precedent, no legal basis, just a quiet step back from the bench. Now let's talk about the attempt to strike out part of the affidavit. The family's lawyer tried to argue that sections of the Zambian Attorney General's submission were hearsay and should be removed. But the court wasn't convinced. Why? Because what the Attorney General had submitted was based on evidence and framed as conclusions, not gossip. For example, based on the evidence, it is clear that that's an interpretation, not hearsay. Trying to strike that out only made the family's lawyer look like he didn't fully grasp what the rules of evidence allow. Another bruise on credibility. And still, the Zambian side kept pushing through calmly, bringing up real legal cases, including one involving Faith Funeral Home, where the judge ruled that competing burial interests must be resolved using common sense, not just legal tradition. So while Lungu's lawyer was busy arguing emotions, dignity, stress, culture, the Zambian side was quoting case law, cross-referencing affidavits, and keeping a structured argument from start to finish. That contrast was clear. Now let me go back to something important. The protest outside the court. South Africans, not just Zambians, were voicing their concerns. Many said they felt the burial of a foreign president on South African soil was inappropriate. Some cited past tensions between citizens and foreign nationals. Others simply didn't want the country caught in another political storm. That protest outside mattered. It showed that this wasn't just a Zambian issue. It had sparked broader feelings. And the court wasn't operating in a vacuum. Judges hear those protests, even if they don't respond. It added to the pressure. So by the time the hearing ended, the picture was clear. Lungu's lawyer had raised strong emotional points, but was repeatedly caught contradicting his own affidavits, misreading legal definitions, and responding late. Meanwhile, the Zambian side stayed focused. Their strength wasn't drama, It was documents. Paragraph 7.6. Paragraph 9.5. The very paragraphs submitted by Lungu's own team were used against them. That's what made the difference. If you're still wondering who had the upper hand in court, let me put it plainly. Lungu's lawyer was out-argued using his own paperwork. He walked into court confident, but walked out looking like someone who tried to play emotion against evidence and lost. That's not me being harsh. That's just how the day played out. So what happens next? The court will make its ruling. But one thing is already clear. The emotional argument didn't hold up. The contradictions were too big. The timing was too sloppy. And the facts, they were too strong on the other side. So what happens next? The court will make its ruling. But one thing is already clear. The emotional argument didn't hold up. The contradictions were too big. The timing was too sloppy. And the facts? They were too strong on the other side. Now I know many of you wanted to watch the full clip. I promised to share part of it. But to be honest with you, it's late here. There's been a development back home, and I have to fly back to Zambia urgently. I won't be able to show you the footage right now. But if you want to watch the full proceedings for yourself, you can go straight to the SABC News YouTube channel. They've got the full recording there. Just search for the hearing from August 4th, and you'll find it. Thank you for staying with me through this breakdown. If you found it helpful, hit the like button. It helps the video reach others who want the real story without the noise. And if you haven't subscribed yet, do that now so you don't miss the next update. I'll be covering the aftermath of this case once I'm back. For now, I need to pack up. There's an emergency waiting for me back in Lusaka. But I'll be back online as soon as I can. Stay safe.